So, if you die without a will, the state of Mississippi says, well, your assets will be divided equally between your spouse and your children, equal shares. That's usually not what people want. Usually, if they have a spouse, they want everything going to the spouse. They don't want their child getting an equal share with their wife. But that's what the intestacy law does. If you want to do something different than what the intestacy law does, you have to do a will or have title to those assets owned in a manner that doesn't pass through that intestate estate. And so that's really the purpose of a will. Is it's your wishes, it's your will as to how you wish your property to be dispersed at the time of your death. It's a testamentary instrument of this is what I intend at my death, not before, but at my death. And so that's really why we have wills. And without it, again, we have a default statute. If you have no spouse, it's going to be equal share between the children. If a child's deceased, it's going to drop down by representation to that child's children. If there are no children and no grandchildren living, it's going to go equally to parents, I believe, and siblings. If a sibling is deceased, I don't remember if it passes through representation or not. It's always it comes across so infrequently that I always have to dust the statute off and see. But it goes out about five. The statute actually goes out about 5 generations, some of which take by representation, others of which do not. And so it would depend in that circumstance as to who's alive if you die without a will, as to who ultimately winds up getting things. There's a misnomer out there of, if I die without a will, the state gets everything, and that's exceedingly, exceedingly rare. Usually, again, the statute, goes out multiple generations. We can, I've never been involved in one that we couldn't find somebody that actually inherited the property that we could make a distribution to through that intestate estate.